to talk about judges' errors. Because, I mean, my understanding of an appeal is that you're appealing the trial judge's errors. It's not a retrial. It's for you to argue that the trial judge has made a mistake. Am I correct in that interpretation?
Yes, you would never say that to the appeal court, that the trial judge made a mistake, but you would say that you would appeal a finding of fact, or you would appeal a determination of law, and that respectfully we believe that the trial judge erred on this point.
Erred on. Okay, so I like to talk about the errors because I keep seeing this phrase, overriding and palpable.
Mhm.
Overriding, can you just explain a little bit about what that phrase is really talking about?
So at trial, as I said before, there will be a finding of fact. So each side will present its version of the facts through witnesses, documents, testimony, affidavits, and so on. So each side will no doubt have a different version of the facts.
Right.
So then it's up to the judge to determine which facts are relevant and which facts are true and which are not true. And so the trial judge will then make a determination around that. So he will make a finding of fact. Okay,
Right.
right? Who did what, when, where, why? So there will be a new version of the facts. Now, occasionally a judge might just accept the version of the facts presented by one side or another, or it
Right.
might be a kind of blend. I mean, this
Right.
side got some of the facts right, this side got some of the other facts right.
Interesting.
Usually it's something like that.
Right.
But the court will make a finding of fact. So it will tell a little story. Like, here are the facts. This is what happened. This
Right.
is what someone said. This is what someone did. So
Right.
that will appear in the decision.
Right.
Right. So the second part of it is to apply the law to those facts
Right.
to determine the outcome of the case. And so both sides at trial will also present their views of the law, and they no doubt will differ on what the law is, what the relevant cases are, and or how they apply. So then the judge will have to make another finding there about which cases are relevant and how they actually apply to the facts of the case. And that will determine the ultimate result. Okay. So on appeal, you can appeal on findings of fact and findings related to the law. Okay. But there are different standards because on appeal, there is a reluctance to call into question the findings of fact by a trial judge because the trial judge got to see the witnesses. He was able to assess the credibility of the evidence firsthand. And so, he or she is considered to be the most reliable source for determining the credibility of all of the evidence. So the appeal court doesn't like to second guess, what the trial judge determined in relation to the facts. However, that doesn't mean it can never happen. So if you want to call into question a finding of fact, you have to argue that the judge made a palpable and overriding error of fact. Okay. So this is a very high standard to meet. So palpable means it's very clear, like on its face, the judge made a serious error. And overriding means that the error, the finding of fact that's an error, determined the outcome. It is material, which means that this finding of fact, actually influenced the outcome of the decision. Okay, if a different finding of fact had been made, you would get a different outcome. So I'll give you an example. I argued this recently in an appeal case here in Ontario with one of my physician clients. So at the hearing, which was not held at a trial court, it was held by a tribunal, the College of Physicians and Surgeons, right, which can run its own hearings under a statute. So that's in effect the trial level. So in the decision of the tribunal, which went against my client who had his license revoked, the adjudicators completely ignored two cross-examinations that I conducted with their expert witnesses, with the expert witnesses of the college. So I actually impeached those witnesses. In other words, I showed that their testimony was in contradiction. Okay. So it's up, when that happens, it's up to the judge or the adjudicator, whoever the decision maker is, to grapple with that and address it. And I find, and to make a determination about whether this is material or not. that witness contradicted himself or herself. You can't just ignore it. Okay? And in this case, the tribunal just didn't even mention the cross-examinations. And so I argue that this is a palpable and overriding error of fact, because it's very clear they didn't consider the cross-examinations. And had they considered them, I argue that a different result would have been reached. Okay, so that's an example of a palpable and overriding error of fact.
That's amazing. That's a really good, like, real example to illustrate these phrases.
Yeah. So and then there's the issues of law. Now, there's much greater latitude on the issues of law. So you can say, you can really make just any number of arguments there. There's no deference shown to the court below on the issues of law.
I see.
Okay. So you can argue the trial judge misinterpreted the case law, didn't apply the right case, or applied the case improperly, didn't get the application right, and so on. So you can make a full range of legal arguments, a full range of arguments about whether the judge got the legal determinations right. So that's really mostly what appeals are about. They're about the law. What is the law? Was it applied properly? And so, but also to succeed on appeal on errors of law, the error of law must be material. So you must show that if a different, finding had been made about, about the law, whatever it may be, law of tort, the law of contract, whatever it may be, that there would have been a different result. And you will ask the appeal court to reach a different result, based on correcting the error of law below.
One final question in this segment of the conceptual questions. What are the possible outcomes of an appeal? I don't know if you know what I'm getting at.
Right. Well, there are three possible outcomes.
Okay.
The original decision will be affirmed.
Yeah.
So the judge got the findings of fact. He got them right.
Right.
No palpable and overriding error. And he or she got the law right too. So we just affirm the original decision. We think the judge thought it through properly and got the right answers.
Right.
Okay. The other alternative is that the judge made errors that were material, either in relation to the facts or the law. So they will overturn the decision, set it aside, and enter a new decision on behalf of the party who's appealing. Okay. So the third possibility is that the decision at the trial level was so poorly reasoned that it's impossible for the court to properly evaluate the issues in the case and make a comprehensive and thorough appeal decision. So if that very unusual situation arises, then the Court of Appeal can send the case back to the trial level to be re-adjudicated.
So it will send back for a new trial, for a retrial, literally.
Yeah, that's right.
That's interesting. Oh, okay. But the Court of Appeal can't do that. Like, they don't do trials.
No, they can't do the trial. So if they think that the trial judgment was really, didn't, was vague or incoherent or failed to address key issues that are obvious in the evidence, there are any number of things that could be addressed there. They will say, no, they're not going to conduct a new trial, but they will send it back to the trial level for a retrial.
Interesting. Okay.
And they might even say, they might say some issues. I mean, it might be within their discretion. I'm not exactly sure. It might be within their discretion to say, we say that these following three issues need to be readdressed, but we're good on these four issues. Right. Yeah. I mean, it might be within their discretion to do that, but I haven't seen a case like that before. But I was just recently reading a case where the Court of Appeal took the position that the reasoning of the trial court was so vague and that it had to be sent back to the trial level for clarification, after which an appeal then could be reheard.
And I guess they have discretion to send it back to the same judge or maybe a new judge. Like, I guess it just depends on the case, right? Like,
that's a good question, I'm sure, because in that decision that I read recently, it was unclear to me whether it would go back to a new judge or to the same judge.
Yeah.
So it's a very unusual situation, so I'm not certain, but they can send it back.
Interesting. Okay.